Good afternoon, everyone. My name is Ryan Helgeson. I'm a senior attorney at McEntee Law Group, here to give you a presentation today about employment-based immigration options, specifically the H, E, L, and O non-immigrant visa options. This presentation is for general information purposes only. It is not legal advice. We are lawyers, but not your lawyers in particular. So please contact an attorney or an accredited representative for individual advice. All timelines provided within this are estimates as of the date of this presentation. They are subject to change depending on the U.S. government's workload and the specific facts of each case. Today we'll be talking about non-immigrant employment-based visas. So I'll give you a little bit of an overview of that. Then we'll discuss H-1B visas, E-3 visas, L-1A and L-1B visas, O-1A and O-1B visas, and then we'll have time at the end for some questions and answers. As it says on the bottom there, I will not be covering E1s and E2s, the treaty trader and treaty investor visas. Those are in a different kind of category than the ones we're discussing today, and would kind of deserve their own webinar to discuss all the details of those. I also won't be covering TNs. If there's time at the end, I will give you some bonus coverage on that, but they're again outside the scope of this webinar. I also won't be discussing the green card process, the employment-based green card process. However, there is an upcoming webinar that we're putting on. They'll be covering the employment-based green card process on November 20th. So please look forward for that, and I'll give you additional information on that towards the end of this presentation. So employment-based non-immigrant visas. What do we mean by this? As is evident from the name, employment-based. So in general, an employer must sponsor the foreign national employee for the visa. The employment-based is distinct from family-based side of law. U.S. immigration is decidedly split between two paths in which to enter the country and which to get lawful permanent residence. The family-based side through marriage or relationships with family members, and then the employment side, which requires to work in the U.S. Non-immigrant part of that, so this is covering temporary status in the United States, not lawful permanent residence, also known as the green card. So these are part-time visas, so you can come in for a specific length of time. Some can be renewed for a long period of time, some have specific limits, and we'll discuss those as we go through. Each of the categories I'm going to discuss today has its own eligibility criteria and employer-employee relationship requirements. There is no one-size-fits-all for U.S. immigration. You have to meet the requirements of these specific visa categories in order to qualify and be eligible for those visas. There's not an option to have a general work visa to come in and look for work. There are some cases where an employment authorization document through different statuses such as asylum or green card applicant can have a more general employment authorization document. But again, you need to be in the United States in another status to obtain those. The visas we're discussing today are very specific and require, you must meet all of the eligibility requirements of those visas to be able to enter on and work on those visa types. So with each of these visa types, I'm going to kind of lay out the basics, just give you some general information, and then dig deeper on each of these topics as we go through. So starting with the H-1B, the position must be a specialty occupation, which I'll define in a moment. They're initially valid for 3 years and can be renewed an additional 3 years for up to a 6-year maximum. There are times when if you're a certain point along in the green card process where you can go beyond that 6-year maximum. But again, that's beyond the scope of this presentation and will be covered in the next webinar on November 20th. And most importantly for the H-1B, as I'm sure many of you are aware, they are subject to an annual quota, which I'll get into a lot more detail about. So what is a specialty occupation? A specialty occupation is a position that requires at least a U.S. bachelor's degree or its equivalent in a specific specialty to enter the profession. So with that, breaking that down a little further, U.S. bachelor's or its equivalent means you can have a foreign degree, which meets which is deemed equivalent to a U.S. bachelor's degree. Generally, a U.S. bachelor's degree is a 4-year program. So if you've got a 3-year degree from say India or Italy, a level 7 from Ireland, that may not meet the requirements of equivalency to U.S. bachelor's degree. Generally, we obtain educational evaluations to determine the equivalency. But if you've been through a 4-year program, in a foreign country that has resulted in a bachelor's degree, it's generally going to be equivalent to U.S. bachelor's, and that position will meet that requirement of specialty occupation. The degree must be in a specific specialty. This doesn't mean one particular field. There can be a range. So for example, if it's a mechanical engineering position, and you have a degree in mechanical engineering, perfect fit. But it can also require, if there's degrees in construction management or a wider range. If it's an intellectual or IT position, then positions, the specific specialties can include computer science or data analysis or information systems. As long as they're closely related, the actual field of your major can be included within specific specialty. Additionally, that's for the position itself. Additionally, the foreign national must possess that required degree, whether it's the specific degree mentioned or in a closely related field. So if you're trying to get a job as an engineer and you've got an accounting degree, that's not going to work. You're not going to qualify for the H-1B in that case. You do need to possess that actual degree. Going into more depth about the annual quota. So there are 85,000 H-1B visas available each U.S. fiscal year. 20,000 of those are set aside for individuals with a master's degree or higher from a U.S. university. So that essentially means if you don't have a U.S. master's, you're down to 65,000 available each year. The company registration, so an employer has to sponsor the employee for this visa. So the company is in charge of the process. They register online each year. That occurs in 2.5 week period in March every year. And then the government conducts a random selection process at the end of March. It is truly random. Other than possessing a U.S. master's degree, there are no ways to increase your odds of being selected. Registering early or anything like that doesn't make a difference. It is a random selection process. Having a U.S. master's degree does increase your odds because of the way they conduct the lottery. So they select those 20,000 individuals first with U.S. master's degrees, and then anyone else with a U.S. master's degree that wasn't selected gets put into the other pool for the 65,000. So you have a slightly better chance with a U.S. master's degree. In general, there are 400,000 to 500,000 registrations a year. So the odds of being selected are 1 in 4 or 1 in 5, depending on the volume each year. If you're selected in the lottery, then the company can file a petition for you with USCIS, United States Citizenship and Immigration Services. That petition is generally filed between April and June each year. And if that petition is approved, you can begin employment under the H-1B starting no earlier than October 1st of that same year. So the process begins in March, you're selected, you petition, and then you begin work in October of the year. October 1st is the beginning of the U.S. fiscal year, which is why that date has been chosen. Not all companies have to go through the CAP lottery process. There are some companies that are exempt from this. Those include institutions of higher education, so colleges and universities, affiliated or nonprofit organizations that are affiliated with those colleges and universities, and nonprofit and government research organizations. So if you have a job offer from one of these categories and it fits, and it's a specialty occupation and you have the required degree, they can apply for an H-1B for you at any time during the year, and you can begin at any time during the year. They're not subject to that, to this March, October timeline that the other cap subject institutions are bound by. Moving on to the E3 visa. The E3 can be considered as the Australian H-1B. It's very similar to the H-1B in its requirements and kind of its standards, but there are some differences to it. There is an annual limit on the number of E3s that are available. There are 10,000 available each year for Australian citizens. There's been no need for a lottery at this point. I don't think they've ever issued more than 5,000 or 6,000 per year. So generally they're available whenever one is needed. There's no cap process or registration process that has been involved for the E3 visa. Again, the position must be a specialty occupation, so it requires a bachelor's degree in a specific field, and the person must have that degree. They are initially valid for 2 years, and there's no maximum. Theoretically, you can remain in E3 status for your entire career. You can keep re-entering on that. Also different from the H-1B is that with the E3, you can initially apply through a U.S. consulate in Australia. So the H-1B, you have to first file with USCIS, get the approval, and then you can begin working on the H-1B. For the E3, if the individual is in Australia, they can apply directly to the consulate and receive their visa stamp and then enter in E3 status that way. There's no need to get the USCIS approval before beginning in E3 status. You can apply through USCIS initially, and you can renew through USCIS if you want, but it's an option to apply through the consulate. So there's a little more flexibility in that case. Moving on to the L1. The L1 visa is for intracompany transferees. The key points on this is that there's a required relationship between the U.S. and non-U.S. entities. The employee must have 1 continuous year of employment at the non-U.S. entity. The important part there is that it's continuous, so you can't work abroad, can't work for the company outside the U.S. for 6 months, go somewhere else for 6 months, and then come back for 6 months and have a year total. It must be a continuous year before you're eligible. There are 2 types of L1s. There's the L1A, which is reserved for managers and executives, and then the L1B, which is reserved for specialized knowledge employees. And again, I'll go more in depth in each of these as we move forward. For the corporate relationship, so there must be an affiliated company doing business in the U.S. and at least one other country. It does not matter which one. There just needs to be a multinational component to it. The company that's outside the U.S. must continue to be doing business the entire time for the L1 to be valid. So you can't have a U.S. company or a non-U.S. company leave it to start a company in the U.S. and abandon that non-U.S. entity. That needs to be maintained for the L1 to continue to be valid. There is one exception to the doing business portion of this requirement. You can come to the U.S. to open a new branch or office of the non-U.S. company. It does make a difference as far as the ability when you have to renew the visa, and I'll discuss that in a moment. But you can come here without a U.S. entity actually doing business. You'd want it incorporated and ready to start before you got the L1, but it doesn't have to be active if you're coming to open a new office for that non-U.S. entity. Again, the foreign national must have been employed by the qualifying entity abroad for at least 1 continuous year, and that year must have occurred within the past 3 years before filing the petition. There are some instances in which that 3-year period can be calculated slightly differently. If you're already in the U.S. on a different visa, it may shift that 3-year period to a different range. But in general, 1 year within the last 3 years. That employment as well must have been in a managerial, executive, or specialized knowledge position. So you must, the position with the foreign entity can't have just been any old position. It must meet the qualifications of managerial, executive, or specialized knowledge, which I will discuss now. Managers and executives. The position must be either managerial or executive. It cannot be a mix of the two. USCIS is very particular about this with the requirements. You can't be, a CEO who's also does managerial type duties. You need to meet the specific definitions of one or the other of those categories of occupation. And obviously that's determined with the attorney at the beginning of the process, which category is most appropriate and what the evidence fits. For the executive, you can generally think of them as someone who controls the operations of the entire company or an entire division of a company. So generally they report only to the board of directors or the CEO. These are generally C-suite employees. So the chief executive officer, chief technology officer, chief marketing officer, chief financial officer, all of the C-suite occupations is generally the executive level. To be considered a manager under the L1A, there's different ways to meet that definition. One, you can manage other professional employees. So these are employees that possess a degree in a specific field. So these are kind of, higher level or sophisticated employees that you're managing. Also, if you manage multiple levels of employees, whether they're professional positions or not, you can also qualify as a manager. So if there's a hierarchy underneath you that involves more than one level, you can qualify as a manager. Finally, if you don't directly manage people, you can qualify as a functional manager if you manage an essential function of the company. So these you can generally think of as operations managers or project managers. So you don't necessarily have direct reports, but you work within the company to oversee a specific function. And you'll work with either other managers to direct that function, or you'll have, in a project manager situation, you'll meet, you'll have different groups of people that you work with at different times to achieve the goals of your position. That's kind of a functional manager. The L1A is initially valid for 3 years, and then it can be renewed for 2 years and then 2 more years for a total of up to 7 years. In contrast to the H-1B, where if you're a certain point along in the green card process, you can go past the 6-year maximum. You cannot do that with the L1, but the total of 7 years is an actual max. If you're coming to open a new office, as I mentioned earlier, that pattern is different. It's initially valid for 1 year, and then you can renew it 3 additional times for 2 years each. So again, it's a 7-year maximum. There's just an additional requirement to extend that visa. At that 1 year, at that first renewal period, you're demonstrating that the new office is indeed up and running now and has enough business and work to require there to be an executive or manager in the U.S. to keep it running. One thing to note about both the H-1B and the L-1A, those maximums of 6 or 7 years respectively, those are only based on physical presence in the United States. So anytime you're outside of the U.S. For more than 1 day, it does not count towards that maximum. So if you take a 1-month vacation on the holidays every year, that time can be what's called recaptured and it adds, a month back on to the maximum date. So it's only physical presence in the U.S. that counts towards the maximum period of time for the H-1B and the L-1A. So that's it doesn't change the validity period of the particular visa you're on. It's still 3 years. It doesn't push out that expiration date, but it does push out the maximum. So as you get near the end of near that max out date, we look at whether or not you can recapture time and push that out and get additional time. For the L-1B visas, these are specialized knowledge. Specialized knowledge is a bit of an amorphous concept. I'm not even certain that USCIS understands it fully, based upon the request for evidence and other issues we see with these petitions. But in general, specialized knowledge is not commonly held within the industry or within the employer. So it's knowledge that isn't, is either unique to your organization, so it could be proprietary, doesn't have to be, but if it's proprietary programs or manufacturing processes that you're working with, that obviously is unique within the industry. And if it's unique within the employer, you're looking at whether or not, this person or this small team are the only ones that really have this knowledge that you need in the U.S. The knowledge must be complex or sophisticated, so it must be something that's advanced, has technological and complicated parts to the process. It can't be janitorial services. No offense to janitors, they're awesome and very important, but they're not going to qualify for specialized knowledge positions under the L-1B. Finally, it has to be difficult to impart to others. This requirement essentially comes into play when you're looking at, USCIS will look at the petition and say, can they just hire somebody in the U.S. to do this? The argument there is that no, we've got somebody who has this knowledge. It's taken them 3 or 5 years to get this particular knowledge. It's not something we can just train somebody in the U.S. on in a month or two. We can't easily give this knowledge to somebody else in the U.S., a new employee. So we have to bring in this person from abroad or outside the U.S. to fill this position. The L-1B is initially valid for 3 years, just like the L-1A, but it can only be renewed for one more 2-year period. So there's a maximum of 5 years on the L-1B. And like the L-1A, in contrast to the H-1B, there's not the ability to extend it beyond that maximum, even if you're at a certain point in the green card process. It is possible to switch from an L-1B to an L-1A to get that additional 2 years. But again, it has to be, you have to be moving up to a manager or executive position to qualify for that L-1A. And that petition has to be filed well before you reach the 5-year maximum to qualify. It's not a last ditch. You can't make a last ditch effort to gain an extra 2 years. Moving on to the O-1A or O-1 visas. So these are the extraordinary ability visas. There's 3 main requirements for the O-1. First, you have to show proof of extraordinary ability in your field. And again, I'll go into more detail on each of these. There must be a petitioner, sponsor, or employee involved. There is a little bit of leeway here as opposed to the H-1B and E3 and L-1, where it's specific employee relationship and ownership interest in the company is generally not allowed. In this case, if you're an O-1, you can open a company in the U.S., you can own a majority of it, then that entity can sponsor you as an individual for an O-1A visa. Then the work you do would be through that company. You'd contract out to your clients, they would pay the company, and then the company would pay you. So there is, it's not technically self-sponsored, but in practice it looks that way. Finally, there has to be evidence that you're going to continue to work in your field of extraordinary ability. You can't have won a Nobel Prize in chemistry and then say, I have a passion for speech pathology. I want to come to the US and do that. You got to be continuing to work in the chemistry field or closely related. You have to be working, doing what you are an expert in. There are two kinds of O1s. There's O1A and O1B. The O1A is for positions that are in the sciences, education, business, or athletics. And then the O1B is for the arts, motion pictures, and television positions. And again, we'll get more in depth on each of these. So the O1A visa, these are science, education, business, and athletic positions. To demonstrate proof of extraordinary ability in your field, you have to provide evidence, strong evidence of at least 3 of these listed categories. So awards in your field, whether they be team or individual awards, they can qualify in this category. You have to have filled a critical or essential role for a distinguished company. So distinguished meaning it has a good reputation. It's known within the field, or even is a household name. Obviously, would qualify for that. But even if it's considered a good company within the field, that would qualify as distinguished. If you have press in the media about your work and the roles you've played, that's indication of your extraordinary ability. If you've made original contributions of major significance to the field, so there's specific things you've done that have either changed, been copied by others in the field, or changed the way certain processes or operations occur within the field as a whole, as opposed to just within your particular company, that would qualify for that. If you have a high salary or remuneration, that's not just objective. It has to be in comparison to others in your field. So there is no specific dollar limit that indicates, hey, you're highly paid. It has to be in relation to other people in your position in your field. If you've authored scholarly articles, presented at conferences, academic conferences, that's another qualification. Membership in outstanding associations. So this isn't just something you pay your dues for and get a membership card. This is a selective organization that you've qualified for. And then finally, being a judge of others, whether it's serving as a peer reviewer for educational articles, acting as a coach and choosing team members, or being a hiring manager, having direct control over hiring in a large swath of a corporation. So you're the one choosing the work, serving as a judge in a competition for high school science fair, stuff like that, where you're showing your expertise is needed to determine who else is good in the field. So you need to tick at least 3 of those boxes to demonstrate extraordinary ability for the O1A. For the O1B, it's similar. Again, you need to check 3 of the boxes for these categories. The lead, starring, and critical role for distinguished companies, that can be thought of more as not necessarily the actors of the production, but more of the behind the scenes people, camera work, sound design, anything like that works for companies that are well known. The lead, starring role in distinguished productions, that's more the actors and those type of roles where you're the star or either the primary character in a production, somebody that is heard of and is on in a distinguished venue. So if you're coming over to play Hamlet on Broadway or in Chicago for a run of shows, obviously that's going to qualify as that lead role in a distinguished production. Press about your work can also demonstrate your extraordinary ability. Expert recognition. So we'd have letters of other people in your field that says, yep, this person is really good at what they do, and they have skills that are unusual and in need. Additionally, you can show major commercial or critically acclaimed success of the product productions you've worked on. And finally, high salary and remuneration. Again, that's, as with the O1A, it's relative to others in your field. There's one question about the D3 waiver. So briefly, if you're subject to something that prevents you from getting a non-immigrant visa, so you have admissibility issues, whether it was a previous overstay or unauthorized work, a criminal history that's problematic. When you apply for the visa, you may be eligible to get a waiver of the inadmissibility to allow you to obtain that non-immigrant visa. So that's under the Immigration Nationality Act, Section 2112 D3, so commonly referred to as the D3 waiver. You apply for that at the embassy at the time of your interview. If they indicate they're going to deny, you'd then file for the waiver at that point. We have another question about whether or not the O1A is subject to lottery limitations. It is not. There are no limits on the number of O1As that can be issued each year. Same with the L1s. There's no limit on that as well. One additional point I should make about the L1s is that in general, you apply through USCIS like you do with the H-1B. Then once it's approved, you go to the consulate abroad, obtain your visa, and come in. There are certain companies that have enough foreign entities are operating in enough countries, use the L1A program a lot, at least 10 or 12 times a year, and make a certain amount of money in the U.S. Those companies are eligible for what's called a blanket L. In that case, employees of that company can apply directly at the consulate abroad to get their L1A. They don't necessarily have to wait for or go through USCIS to get an approval. They can come in through the consulate. But in general, the process is through USCIS. As promised, I will give you a little bit of bonus coverage on TN visas very quickly. It didn't fit into our acronym to make it cute and clever. But I will cover TNs. It's very similar to an H-1B or E3, except the TNs are limited to individuals that are citizens of Canada or Mexico. And instead of the specialty occupation requirement, there is a specific list of occupations that is eligible for the TN visa, and then specific educational requirements for each of those occupations. So you can, you have to meet the requirements of, fitting into that occupational classification, and then show that you have the education required by that, whether it's a bachelor's degree or a certain amount of experience. The occupations are more limited than they would be under the H-1B. There's very specific categories that you can fit into. If you're a Mexican citizen, you apply initially through a consulate, a U.S. consulate in Mexico, and obtain TN visa to enter. If you're Canadian, you don't need a visa stamp. Then you can apply at the border or the port of entry when you come in. Otherwise, it's quite similar, in kind of process to the others. You can apply from within the U.S. Through USCIS and get an approval notice prior to either going to the border or going to the consulate if you've got specific concerns. But otherwise, you can go directly to the consulate or to the port of entry, depending on where you're from. They're initially good for 3 years. They can be renewed indefinitely as long as you continue to meet the requirements. It's not a direct path to the green card as the H-1B would be, but there is no annual limit on that either. You can continue, you can apply for those at any time during the year. We've got a question on spouse or long-term partner eligible. to accompany the individual on the visas. Long-term partners, the answer is no. You must be married in order for the individual to qualify as a beneficiary or a derivative beneficiary under these visas. For the H, they would get H-4 status. That does not come with employment authorization until a certain point in the green card process is reached. So generally no employment under an H-4. Same with the E3, spouses or unmarried children under 21 are not employment authorized. And with the O, the spouses and unmarried children under 21 would get O3 status, again, no employment authorization. The L, however, allows spouses, so you get L2S status. They can work incident to their status. So when they enter the U.S., they'll get an I-94 from Customs and Border Protection that indicates their status is L2S. They have employment authorization. They're not tied to a specific employer. They can work anywhere that doesn't require U.S. citizenship to be employed there. So that's one big benefit to the L1 category, as opposed to the others, where employment authorization isn't readily available for spouses. We have a question about for the H-1B, is the employer required to hire for a 3-year period? No, it's not a contract. The H-1B is at-will employment, as most positions are in the U.S. So you can be terminated at any time for any lawful reason. If you're terminated before the end of your period or end of the validity period, you have what's called a 60-day grace period within which you can apply to change status or apply to apply for another H-1B with an employer. If you get that petition filed before the end of the grace period, you can remain in the U.S. while it's pending, and then begin work or that new status at the time it's approved. Once your grace period ends, though, you will have to leave the U.S. or you'll accrue unlawful presence. There was a question about there being a list of the L blanket companies. There is no specific list of those companies that qualify. Basically, you would have to know which ones, if you had an offer of employment from them, they would be the ones to determine whether or not they have a blanket that could let you do that. Additionally, for H-1B cap exempt companies, there's no master list out there that shows whether or not they meet the qualifications of cap exempt. In general, it's all universities and colleges that are accredited, and then they're affiliated institutions, nonprofit institutions. So if it's a university or college, you can be pretty certain they're cap exempt. But for private institutions or government research institutions, it's not clear. The company themselves would likely know if they've gone through the process before whether they're cap exempt. But if it is their first H-1B, they'd have to meet with an attorney to determine whether or not they qualify for that. And then finally, we have one question about transferring H-1B visas to another employer. So if you've been through the cap lottery one time, you don't have to go through it again to change employers. There may be issues if your initial employer was cap exempt and then you want to go to a cap subject employer. You may have to go through that lottery process to switch employers. But in general, you are allowed to change employers under the H-1B. The new employer would file a whole H-1B petition on your behalf. You can switch to that new employer as soon as the H-1B petition is filed with or received by USCIS. You don't necessarily have to wait for approval to change employers. Obviously, there's a risk involved with that. If it is denied, then if your previous employer has terminated or withdrawn the H-1B, then you've fallen out of status. Or you can, so to alleviate that, you can wait for approval to begin working at the new H-1B employer. They're allowed to apply for up to 3 years maximum, or the end of your 6-year maximum period, depending on when that is. So it is possible to transfer, and it's basically a whole new H-1B petition. There's no particular no requirements are different from an initial H-1B. Then we have a final question about O-1A requirements. So yeah, in general, they're asking about how you see whether or not you're qualified for an O-1A. Our practice is to meet with the client, go through all the requirements, kind of talk to them about the evidence they may have, and make a determination on whether or not it's a strong case, whether it's whether the totality of that, whether they check those 3 boxes initially, and then whether the overall picture demonstrates extraordinary ability. We make that determination before we file. Nobody benefits from a weak case being filed. We would explore other options if the O-1A isn't a good fit for you. We'd look at other options that could be a fit. But yeah, we make that determination of criteria and the strength of the case before we file. It's kind of our initial step, is assessing that evidence. All right, I think that's all. Thank you everyone for joining us today. I really appreciate it. So again, thank you very much. Everyone have a great day.